happy last day of school this week. Happy Constitution Day. Who's coming to see fireworks tonight? By the way, it might rain, it might not. But if it rains, it will be the most epic fireworks show ever. Get wet, dance in the rain. We love the rain. We pray for rain. The revolution was won in the rain. We don't mind rain. Actually, the weather looks pretty good, so come celebrate with us. If you are just filing in, thank you for joining. Please, if you have any non-uniform articles of clothing, please take those off. Let's unify, especially on a day when we are talking about the letter and the spirit of the law, Constitution Day. We are so honored to have with us today a Utah Supreme Court Justice, now in private practice. Tom Lee will tell you a little bit more about him after the song and prayer. Let's have our choir go ahead and come up now. Choir, come on and form. We will begin with an opening song called Things That Never Die. The text is by Charles Dickens, music by Lee Dangler, chamber choir is conducted here by Mr. Swenson. Yep, and Dixie Choquet on the piano. Let's give them a big round of applause. Opening prayer will be offered by Harvest Hale. And I'm going to say just a few things about Tom, our guest speaker this morning, before Liz gives a formal introduction. Okay, choir, take it away. We love you.
Dear Heavenly Father, we are so grateful that we get to celebrate Constitution Day and to be reminded of the blessing it is to live in America and to be free. And we're so grateful for the school's efforts to teach us about our history And we're so grateful for thy gospel and pray that thy Spirit may be with us today. And we say these things in the name of thy Son, Jesus Christ. Amen.
I know everyone wanted to clap for that. Just hold on, because I want to hang on to the spirit we're feeling right now, okay? Every now and then in life you cross paths with someone who has really consecrated their lives to eternal principles. Tom Lee is one of those. We're glad he's here. We're lucky he's here. He's the kind of person that we might get once in a lifetime to come and speak. He's a friend of Mrs. Acuna's, longtime personal friend. He's a friend of Mr. Ong's, who is the new designated captain of our mock trial team. Not the captain, he's the mentor guiding us through that. And he was almost a professor of mine at law school. I wished I had had him. I didn't. He was a teacher at the time, but he is one of the few men and women in the country who could be a Supreme Court Justice of the United States. Tom, many of you know, was recently stepped off of the Utah State Supreme Court bench, and I'll let Liz give the formal introduction, but I want to just read to you from a book that I picked up in law school. It's not just about what Tom is, it's about what his family is. Some of you may know that he is the brother of Senator Mike Lee. Your brother had some children here before he left to be a senator. You probably know that, so you had nephews and a niece here. And he is the son of Rexley, the United States Solicitor General from 1981 to 1984. Tom's father argued, I believe, more cases before the Supreme Court than any other solicitor in the history of the country. Is that right? Almost right. Pretty close. A lot. And I picked up this book because I was thinking there might be something in here about Rex. And in fact, there was. And it was written by President Nelson, Russell M. Nelson. I don't know if you even remember this about your father in this book. But you've got this in you too, Tom. It was then Elder Nelson who was speaking in 1990 to the law school community, and he said that this scripture about King Benjamin reminds us how fortunate we are to be touched by the majestic spirit of Rex Lee, president of Brigham Young University. His example of courage and candor, fidelity and love constitutes a model worthy of our emulation. He teaches us to keep our vision on the eternities ahead, yet to live and enjoy each day as if it were our last. So here's a little bit of who you're about to hear from today. I'm going to turn the microphone over to Mrs. Acuna. Tom, I'm going to stay as long as I can. I need to run for a call at about 9:15, but we'll start taking questions at about 9:15, 9:20. Liz, we need to conclude at 9:30, is that right? If you have any questions about democracy, about constitutional governance, thinking, what's going on today, this is a man who could give you answers for the ages. So think about those questions. You'll have about 10 minutes to ask. Some of you will be lucky enough to get an answer. All right? Liz. Mrs. Acuna, sorry.
Good morning, dear. It's nice to see you here. Thank you for being in uniform and for being respectful this morning. This, as Mr. Beckwith mentioned, this is a real unique and wonderful opportunity for you to hear from Mr. Lee. I'll just give you a little bit of his background. Thomas Rex Lee was born in 1964 to Janet and Rexy Lee. Rex, as Mr. Beckwith mentioned, was a former president of BYU. Lee attended BYU, then attended the University of Chicago Law School, where he served on the, I can't remember what it's called anymore, the publication they got there, the Law Review. He was editor of the Law Review there, and he graduated with a J degree with high honors. After law school, Tom served as a law clerk for Justice Clarence Thomas on the United States Supreme Court, and then he later joined the faculty at BYU's J. Reuben Clark Law School, where he worked as a law professor for many years. In 2010, he was selected to serve on the Utah Supreme Court. He retired from the court this summer in order to start not one, but 2 law firms. He was a neighbor of mine for 12 years and is a wonderful friend to my family. He loves to run and water ski, and I believe he attends every BYU basketball game. I've never known a more avid BYU basketball fan. He and his wife Kim have 6 children and 3 grandchildren. Is that right? 3? 5 grandchildren. While Mr. Lee has an incredible intellect, the attributes that I most admire about him are that he is also a devoted husband, a caring father, and a loyal and kind friend. Please join me in welcoming Mr. Lee to AHS today.
Thank you so much, Mrs. Acuna, and Liz and I have been friends for a very long time, and it's such an honor to be with you today. I want to welcome those who are on the live stream with us today as well. I want to start by showing you a little bit of a graphical representation of what an amazing privilege you have to live where you live at the time you live on this earth. I don't know if you realize this, and I don't know how well you'll be able to see this, but I'm going to try to show this to you. But you are a tiny sliver of God's children who have been privileged to come to the world at a time and in a place where you live under a constitution that protects your rights. It is not a perfect system that we live in, but it is a God-given system, and it is such an amazing blessing. So you may not be able to see everything on this graph, but I'm going to just sort of hit play here in a second and tell you about the colors. So down here is, the blue and then the light blue basically are people who have lived in some form of a democracy. When you get up into the orange and the red, people who have lived in closed autocracies or some sort of electoral autocracy. This goes back to 1800 to today. Let me sort of play this for you. Watch this over the history of time and think about the blessing that God has given to you to live in this society. All right, I'm going to start my slides, and I don't know how to get there now. I thought I did. There we go. Maybe I did. Okay. All right, so we are going to talk today about the United States Constitution. And I want to talk to you about here we go. Talk to you about a number of things. I want to talk to you about the way we interpret the Constitution and how it affects our society in significant ways. I'm going to talk about, in particular, we're going to make reference to 2 really important Supreme Court decisions that were just handed down in the last year. So this will give us some concrete examples to refer to. We'll talk about Roe versus Wade. That's not a recent case, but we'll talk about Roe versus Wade in comparison to the Dobbs decision that overruled it. These are cases that deal with whether there is a right to an abortion. Okay? And then we're going to also talk about the Bruen case, New York State Rifle versus Bruen. This is a Second Amendment case that raises questions about the right to bear arms. All right, so what I want to talk about first off is just what is this document? What is the United States Constitution? How does it protect our rights? Normally when we think about the Constitution, we think about the Bill of Rights. The Bill of Rights is extraordinarily important, certainly. And we're going to be talking about a couple of amendments. The first 10 amendments are generally referred to as the Bill of Rights. We'll talk about the Second Amendment in connection with that Bruen case. We'll also talk about the Due Process Clause in the 14th Amendment. Those are really important principles. Those are principles that guarantee fundamental rights for us, including in the First Amendment, the protection of our right to free speech and our right to the free exercise of our religion. But those aren't the only provisions of the Constitution that protect us. In fact, the genius of the United States Constitution is found much more in its initial provisions in Articles 1, 2, and 3 than anywhere else. So we'll talk about this a little as well. So Articles 1, 2, and 3, of course, set up the three branches of our federal government. Article 1, the legislative branch. Article 2, the executive branch. And Article 3, the judicial branch of our government. We refer to this as the separation of powers. We'll talk about that a little bit in connection with these cases. The idea of checks and balances. When I showed you that graphic in terms of the privilege and the blessing that you've been given to live where you live at the time in which you live, I want you to think about this. In the history of the world, where you saw all of those many, many decades, going back centuries, almost everybody who's lived on planet Earth lived in an autocracy. What do we mean by an autocracy? Essentially, it's the absence of separation of powers, right? It's the absence of checks and balances. It's the idea that a single executive, often a monarch, some sort of a despot, somebody who had ultimate power to make all decisions with respect to the government. And when that happens, we don't have very many freedoms. So these articles protect us in that way by separating powers. We'll talk about that as applied. That's not the only way that the Constitution protects us structurally. It protects us structurally by a principle called federalism. So federalism is reflected in a couple of ways in the Constitution. It's reflected in the limited powers of the federal government in Article 1. You can look at Article 1 that lays out specific, enumerated, limited powers of the federal government. And the implication that's reflected in the language of the 10th Amendment is that all other powers reside where? In the people, at a local level in the states. And we'll come back to that as well, because this is also so important in terms of protecting our rights and our interests. We are protected not just by statements of rights in the Bill of Rights, but by structural principles built into the Constitution, essentially that are dividing and splitting power. Power is divided in two ways. One, sort of across the federal government. Articles 1, 2, and 3, that separation of powers. And then the government's powers are divided also vertically between the federal government and the states. That's this principle of federalism. All right. Now I want to get into some, a little bit of nitty-gritty in terms of constitutional interpretation. Any of you pay any attention to Justice Jackson's confirmation hearings recently? The newest member of the United States Supreme Court. This came up quite a bit. She was asked a lot of questions about how will you interpret the Constitution? What will your approach be in interpreting the Constitution? There are essentially two approaches to interpreting the Constitution. This is one of the main things I want to talk to you about today. And they fall into these two categories. One of them we refer to as originalism. And the idea of originalism is that the meaning of the Constitution is fixed. It means what it said when it was established, when it was ratified by the people. It gets amended over time, and its meaning changes when it's amended, but otherwise it stays static. It stays fixed. That's originalism. What about living constitutionalism? It's essentially the opposite of that. It's the idea the meaning of the Constitution evolves in accordance with contemporary values. These are approaches that different judges over time have articulated in terms of their approach to interpreting the Constitution. Why might someone propose to be a living constitutionalist? Let me present sort of, I think, the basic thinking behind this, and I'll give you some quotes from Justice Brennan, who was an advocate of this approach. One of the arguments, it goes to the language of the Constitution. The idea here is the Constitution is written in these broad, glittering generalities. Look at the guarantee of due process of law, of equal protection of the laws, of a right to free speech. The idea here, from a living constitutionalist perspective, would be those provisions are aspirational. They are stated at such a high level of generality that they are meant to be adapted and to evolve over time. Another is, well, originalism is just too hard. We can't recreate the culture and the linguistic context of the framing of the Constitution. So that's a fool's errand, the living constitutionalist would say. We're not going to be able to recreate it. And then thirdly, it would be, this is what's sometimes referred to as the dead hand problem. The idea that if you follow the original meaning, that meaning is just too unjust, too unfair, too incompatible with contemporary moral principles. We don't want to be ruled by that dead hand. As I said, Justice Brennan was an advocate of this position. I'm not going to read the entire quote that's up there on the screen, but you can sort of skim that over and get a sense that he's articulating some of the values, some of the arguments that I just suggested here. This is sort of, the Constitution is the lodestar for our aspirations. This is the glittering generalities point, the idea that it's stated at such a high level of generality it needs to evolve over time. He's also getting at the dead hand problem here, right? He's also saying, look, another problem is the egalitarianism that we aspire to has been more pretension than realized fact. We haven't gotten to what we aspired for. That's kind of what he's getting at here. Here's another, he's sort of getting here at the idea that we really can't recreate the past. We can't sufficiently understand the original meaning. This is sort of, it's just hard and it's stated in these cloaks of generality. This is another sort of dead hand principle. That world is dead, and the genius of the Constitution was in its adaptability. Okay? So that's sort of the essence of living constitutionalism. Roe v. Wade is a living constitutionalist opinion. In 1973, the United States Supreme Court decided the Roe v. Wade decision. In deciding Roe versus Wade, it looked to and relied on, to the extent it relies on a provision of the Constitution, it relies on the due process clause of the 14th Amendment. Doesn't attempt to understand the meaning of due process of law in the era of the founding of the Constitution. Instead, it says, look, we think that we can find in this principle an aspiration for a right to privacy. And it says, look, in the past, the court has decided other rights of privacy cases, has held that there's a right to birth control. And in light of those precedents, the court says, we're going to extend them and conclude that a woman has a right to an abortion. Now, the court in so doing says, well, there are also these countervailing interests. We think women have a right to choose, but we also understand that the state has a right to protect life. And it has a right to protect women's health. And so how does it go about balancing those? It comes up with this trimester framework. I'm not going to restate everything I have on that third bullet point, but attempts to sort of lay out this, here's going to be the standard, this is going to be our attempt to balance these competing interests. Now, importantly, I'll come back to this in a minute, but importantly, this is not an originalist decision. This is a decision that is based on the idea of the court's understanding of our nation's morality in 1973. Okay, we'll come back to that. All right, what about let me put this in terms that President Oaks recently stated it in a conference address about defending our divine Constitution. The Constitution, he said, is unique because God revealed that He established it for the rights and protection of all flesh. The stature of the Constitution is diminished, he said, by efforts to substitute current social trends as the reason for its founding instead of liberty and self-government. Now, this sounds to me like he didn't use the word originalism, but I'm going to go ahead and say, in my opinion, part of what he's getting at is the idea that another reason for us as Latter-day Saints to believe in an original understanding of the Constitution is that it was divinely inspired. Now, importantly, here, quoting President Clark, he said, look, it was not a fully grown document. So here we can kind of get at the, well, to Madison and Hamilton, that they have all wisdom? Well, no. The Constitution certainly is supposed to evolve and adapt. We believe it must grow and develop and meet the changing needs of an advancing world. Okay? Is this living constitutionalism? Well, this is why the title of my remarks is A Living Constitution ? In a sense, our Constitution does evolve. It does adapt. When we get to the Bruin decision, the Second Amendment case, I'm going to talk to you a little bit more about another way that our Constitution has to evolve and it has to adapt outside of the amendment process that I've already mentioned. We don't see inspiration in every Supreme Court decision, and inspired amendments abolished slavery and gave women the right to vote. This is kind of one of those that I liken to the idea of an ongoing restoration. The Constitution was divinely inspired. It wasn't fully baked. It wasn't fully developed. That's an important principle as well. All right, let me talk to you about Dobbs, and then we'll talk about Bruin, see if I can kind of wrap this up and leave time for questions. How many of you have heard about the Dobbs case? How many of you are aware that the Supreme Court overruled Roe versus Wade a few months ago? So this is pretty impressive. Many hands, most of the hands are going up. I imagine part of that is because I'm at the American Heritage School, which, what an awesome school you have here, by the way. What an amazing, so that first slide was what an amazing blessing to be born in the United States of America at the time when you were born. Most of you were born probably in the 21st century, yes, yeah, probably all of you, right? I'm not good at math, but yeah, all of you would have been born in the 21st century. Maybe not Jacob, but most of the rest of you. What a blessing it is, not only all of that, but what a blessing it is to be able to go to school here. Think about that, pray about that, express gratitude to your Father in heaven of the blessing you have to be here. I imagine this is also not a perfect school. It's probably more perfect than a lot of other schools. Go home and thank your parents for letting you be here. Many of them have sacrificed so that you could be here and so that you could have this blessing and this opportunity. Okay, let's talk about Dobbs. I was going to say one other thing. I imagine one reason all the hands are going up is that you're here at this amazing school. Then I got sidetracked on be grateful. By the way, gratitude is so powerful. Every day you want to go out of your way to find something that you haven't thought of that you're grateful for. Keep a gratitude journal. Write something down that you're grateful for. That'll really help you. What I was going to say is, the other reason I imagine so many people are aware of this is a huge decision. There are lots and lots of people that are really angry about this. This is a very difficult problem. I believe that it's the correct decision. I believe that it's correct in large part because it's originalist, which I'll describe in a second. But I also believe that there are many, many people who feel really strongly the other way. So one of the reasons why many of you are aware of this, even though you're not aware of most Supreme Court decisions, nor necessarily should you be, there are lots of other things that are important for you to be thinking about and reading and learning. But one reason you're aware of it is all this angry protest going on that you may have seen on social media, you may have read about elsewhere. This is a legitimate debate to have. Lots of people feel really strongly about their personal autonomy, about the decisions that they want to be able to make as they see it to control their body. Now, I see that one differently, but the beauty of our constitutional system and the essence of the Dobbs decision is not, in Dobbs the Supreme Court isn't saying, oh, we stared up into the sky and thought about due process and we concluded, no, it isn't a trimester system, it's something else. It didn't sort of go with this living constitutionalist approach of we're conservatives and we think the answer is a different one. That's how most people portray Dobbs, by the way. In social media and in mainstream media, a lot of outlets, it's like, oh, these are Trump appointees to the Supreme Court have now kind of taken over, and they're going to mandate on you their conservative politics and their conservative principles. That's the story. How many of you heard that story? How many of you are aware? That's not what this decision says, and it's not what it does. You ought to go and read it. It's a fascinating opinion. It's written by Justice Alito. It's not about any of those things. It's about originalism, and it's about federalism and separation of powers. Because what the Supreme Court is doing in Dobbs is it's saying, no, it turns out there is no basis in the language of the Equal Protection Clause of the 14th Amendment for establishing a constitutional right to an abortion. The Supreme Court observes in Dobbs, the Constitution doesn't mention an abortion, the right to an abortion. It doesn't have anything to do with abortion. And if you're trying to understand the original meaning of the Constitution, you need to look to its language, and you need to look to the history of our society. What are you going to find in the history of our society? You're going to find that, yeah, history had something to say about abortion, but it wasn't to protect a right to an abortion. It was to criminalize the act of getting an abortion, or the act of performing an abortion. In light of that history, the Dobbs opinion says if we're going to take seriously our job of finding the original meaning of the Constitution, we can't establish a Supreme Court sort of balancing test for an abortion right. That's what legislatures do, right? Legislative bodies, they take input from different constituencies, from different individuals, and they balance. That's what the Supreme Court was doing in Roe. You might think, or at least some people might think, maybe Roe is a better outcome than Dobbs. But what Dobbs says is not, we know the right answer to this balance between these interests, but that balance is for another branch of government, and it's for our federal system to work out through laboratories of democracy. That's sometimes how we think about the principle of federalism, right? So New York can have one approach to balancing the interests of the autonomy interests of a woman against the state's interest in protecting life and protecting women's health, etc. And New York can have one approach, Texas can have a different one, Utah can have its own law. That's what this decision does. It overrules Roe, and it does so on that basis. All right, let's talk about Bruin for a minute and kind of connect it up with my question about, do we have a living Constitution? And then wrap it up and leave time for questions. All right, so there's a New York law that says this. It makes it a crime to possess a firearm without a license, either inside or outside of your home. That part becomes somewhat important. Even inside your own home, you have to have a license to possess a gun. Secondly, and this I think is one of the key parts to understand about the New York law, to carry a firearm outside the home, you have to get a permit, and you have to, when you get your permit, you have to make this showing. You have to go to the government permitting office and show that you have a special need for protection that's different from the general population. So, for example, if you have threats against you, if you can show that you live in a particularly vulnerable situation in some way, you may be able to get a permit. But if your interest in having a permit to protect yourself is just the same kind of interest that other people have, New York law says, no, you can't get, or you don't have a right to possess a firearm outside of your home. And then this lawsuit is brought. So here's a check and a balance, right? We talked about checks and balances and separation of powers. Let me relate that to where we started this discussion. In the history of the world, if the government decided you don't get to have a weapon to protect yourself and passed a law to that effect, and you said, I object, well, probably you were going to get executed or something, or drawn and quartered or something. But if you objected, the other thing is, who are you going to object to? same person that enacted the law, right? In the history of the world, we had autocracy. We had kings and queens. We had dictators and other autocrats. And the idea of an autocracy is all power is just resides in one individual. And so if you object to the law and you say, well, that's not fair, that's not right, the response is going to be, wrong, I disagree with you, I passed the law, and by the way, I'm not only going to enact the law as a legislature, I'm not only going to interpret it as a court, but I'm also going to execute the law. So here we've got legislative, judicial, and executive power all in one person. What does the executive do? Well, the executive says, oh, and by the way, you object, I don't like that you object, go to jail. I'm going to put you in jail now, or I'm going to draw and quarter you, or whatever. Okay, so you can see where when we consolidate all of that power in one body, we take away the genius of the Constitution, which was separating those powers. So in our system, you have a right to object, and the basis for objecting is I'm now going to go to a different body, the courts, to challenge the legislative enactment that was adopted by the legislature. And here, they do so under the Second Amendment. This is the language of the Second Amendment. Think about, think about living constitutionalism for a minute. Living constitutionalism, and think about Roe v. Wade. Living constitutionalism was premised on this idea that, well, the Constitution, it's just stated in such broad generalities, we can't really know what it means. It's just aspirational, so judges should just decide what's best for us going forward. That's what Roe did as a matter of due process. That's not what this court is doing in Bruin, not what this court did in a case called Heller, that initially interpreted the Constitution, the Second Amendment, in accordance with its original meaning. How does the court go about interpreting the Second Amendment? It's looking at historical materials. It's looking at Federalist papers. It's looking at ratification debates in the states to try to understand, as best we can in the 18th century, how did the people who ratified the Constitution, how did they understand this right to keep and bear arms? So this is essentially the holding of the Bruin case. The Bruin case says that the regulatory challenges posed by firearms today, they're not always the same as those that preoccupied the founders in 1791. So here's where I'm going to get into a living constitution. Is there a sense in which, even in the judicial branch, the Constitution has to adapt and has to evolve? And the answer to that question is yes. An originalist accepts and understands that by necessity, there are going to be applications or extensions of the Constitution that the founding generation never thought about, didn't consider, and didn't think about. If you ask an originalist question under the Second Amendment about would the framing generation have thought that there was a Second Amendment right to keep and bear an AK-47, what would the answer to that question be? They wouldn't have thought about that, right? Did James Madison think about an AK-47? No, he did not. It didn't exist. There wasn't an understanding of that sort of thing. Let me give you another example. The Fourth Amendment protects our right to privacy, our right to be secure in our homes against unreasonable searches and seizures. There was an interesting case that came up a number of years back called Kylo, United States versus Kylo. In Kylo, the question was, so Kylo had marijuana plants growing in his home. Not a good idea, don't do that, it's illegal, okay? But he asserted that the government had violated his Fourth Amendment rights by searching his home. What had happened and what had the government done? The government had come to his home and set up an infrared detection device that could detect the infrared waves emanating from a marijuana plant inside someone's home. And Kylo said, that's a search, and that infringes my Fourth Amendment right against unreasonable searches and seizures. This is another example of an illustration of how even originalism has to accept the possibility that the principles embodied in our Constitution have to be able to adapt to take account of new circumstances that the framing generation wouldn't have thought about. Does this make sense? So, let me put it in this way. If you ask sometimes we think of originalism in the following way. What would James Madison have thought about this problem? I use James Madison just because he was a principal author of the Constitution. So, let me put the question I put a minute ago. What would James Madison have thought about infrared devices? Would he have thought that they were an unreasonable search and seizure? Yes. So in one sense, the answer is James Madison didn't think about infrared devices. So that's kind of a nonsensical question in that way. This is the way originalism deals with that problem. Let me illustrate it as applied to the Bruin case and then wrap up. In the Kylo case that I just mentioned, the way the majority opinion dealt with that question was to say, yeah, that is a search. And it's a search not because we found evidence from the 18th century that the framers of the Constitution were worried about infrared devices. It's because we went back into the historical documents to understand the conceptual meaning of the protection of the right against unreasonable searches and seizures. And the concept that they find, I'll oversimplify it a bit, but essentially was, if the government is doing something that gives the government information about private information that you have within your household that it couldn't get without entering into your household, then that's a search. That's essentially the concept. And so what an originalist says is that the original concept of the Constitution is fixed. It stays in place. Does it evolve? Does it adapt? Yes, to some degree, because it has to take account of new circumstances. But we try to recreate or understand the original concept and apply it to new circumstances. This happens with free speech as well. What would the framers have thought about the internet? They wouldn't have. They couldn't have understood what the internet was. We could still try to recreate the original understanding of free speech. And that's what the Bruin case is doing. The Constitution can and must apply to circumstances beyond those the founders specifically anticipated, even though its meaning, the conceptual meaning, is fixed. So this is the holding to decide whether a firearm regulation is consistent with the Second Amendment. We have to ask these questions. Whether modern and historical regulations impose a comparable burden on the right of armed self-defense, and whether the regulatory burden is comparably justified. So we're trying to find an original concept about what the Second Amendment protected, and we're applying it to today's circumstances. And the New York Rifle Association versus Bruin case reaches this holding. Historically, American governments have not broadly prohibited the public carry of commonly used personal firearms. So that's the original concept. Was it a commonly used personal firearm? This is how you'd answer the AK-47 question, by the way. They didn't think about AK-47s, but they did think about, you had to have a firearm that was commonly used for personal use, and then you'd ask, well, does an AK-47 meet that description today? Historically, our governments haven't generally required law-abiding, responsible citizens to show a special need for self-protection. That's the basis of the holding. It's originalist, but it adapts to new circumstances. I think that fits with my understanding of an inspired Constitution that wasn't perfect, but that was meant to be fixed in terms of its original concepts. Thank you for letting me be here today.
All right, thank you, Mr. Lee. Do any of you have any questions that you want to ask?
Okay, right back here.
So, what is your opinion on this? Who should decide the laws on abortion, and should it be federal or state? Yeah, Jordan?
Yeah, that's a great question. I'm going to repeat the question for those who are on the stream. The question was, what's my opinion on the abortion question, and who should decide it? Should it be a federal or a state? That's a perfect federalism question. It's also a really timely question because there's a bill that's been proposed in the United States Congress recently to establish a federal prohibition on abortion, to set the line. A lot of this is about line drawing, right? Lawmaking, much of lawmaking is line drawing. It's balancing competing interests, and it's deciding where to draw the line. And yeah, there's a federal bill pending. I haven't thought a ton about this, so I won't give you a firm conclusion to the can this be a federal thing, but there is a separation of powers. Well, there's an enumerated powers question embedded in your question. One way to think about this would be, we ought to look at Article 1, and we ought to think about whether under Article 1, Congress has the authority to enact a restriction on abortion. One of the basic ideas of federalism is the federal government only gets to regulate in areas that are specifically enumerated in the Constitution. If you're going to get there, it's probably under Article 1, Section 8, which gives Congress the power to regulate interstate commerce. I think I'd probably have a difficult time myself finding a basis for it there. I won't say conclusively that I don't think Congress can do it because I haven't studied it carefully enough. I will say this, as a matter of what makes sense to me as a policy matter, I go to the laboratories of federalism point. I think we are so much better off letting each individual state make their own policy judgment on this question. I referred earlier to comparing New York or California to Texas or Utah or something like that. The citizenry in those states is going to have very different views on this matter. A big part of what the framers of the Constitution were trying to do was to, and this was part of the genius as well, leave most of the really important day-to-day decisions to local and state governments. Criminal law, I think, was thought to be left to local and state governments for the most part, and at least as a policy matter, I think that's the way I would handle it. Yes?
Do you believe that President Biden is using historically apolitical organizations such as the FBI, the IRS, and the rates to discredit his political opponents and veterans?
Wow. What a great question. It's probably a whole nother assembly. Can we got another hour for this? Do another one of these? So the question here was whether I think that President Biden is abusing the historical powers of the FBI and other entities of government in an improper way to affect the upcoming elections, I think is essentially the question. That is a great question. So when I was a judge for 12 years. When I was a judge, and there are many beautiful things about being a judge. One of them is when you get to wear a black dress, and when you walk into a room, everybody stands up. And by the way, thanks for that standing ovation. Thank you so much. That was so nice. Really appreciate being here. And so what I would always, for 12 years, to that kind of question, I would say I can't talk about that because judges are apolitical, and we can't speak in public about high-profile. Disputed questions of public policy. I can't really get out of that question that way anymore because I'm not a judge anymore. I will say this, we don't have an hour to talk about it, but I'm very worried about that. I share the premise of your question for sure. If we start thinking of investigative powers of government as a political weapon, I think our Constitution will be in great jeopardy. And I am very concerned that that might be happening. Maybe one more, or should we end? There's one more question, is that all right? Okay, one or two, go ahead.
Wow, you all bringing it today.
So the question here for those who are on this student loan debt was constitutional. Sorry, I got a dry mouth thing going on these days. I have to keep sipping water. Kind of have the same answer to this really good question. We need an hour, and so used to being a judge, I would just dodge that question. I can't dodge it anymore. I'll mostly just give a similar answer. It's a really important question, and you all are thinking about the right issues and the right questions. Let me say this about that question before I give a little bit more of an answer to it. One of the things I love about that question, at least as I'm understanding it or interpreting it, similar to really all three of these questions, you are asking process-based questions, not just outcome-based questions. There's a tendency in the world we live in today, in sort of the Twitterverse in particular, for people to just go sort of straight to the bottom line, straight to, do we think that's a good idea? Will that help me? Or it help you? I mean, I have children whose student will probably like to have student loans, some of their student loans forgiven. There are lots of people who sort of think about government in terms of, what can I get out of it? What sorts of goodies can government provide for me? Is it going to benefit me? We have a tendency to think about government spending as if it were monopoly money, as if it, we just print more of it, it doesn't matter. I mean, all that's just so wrong. And it's so important to my point about the process nature of the question. You're not just asking, would I like to have student loan forgiveness? You're asking, do I think the President of the United States has the power to do that? That is the right question to ask. If we can't ask process-based questions, if we're just going to demonize anybody who disagrees with us and you're an idiot or you're evil or you have a bad motive because you're thinking about this differently from me, if we can't have a reasoned civil debate about who has the power to make certain decisions in our government, our republic will be in jeopardy. So we have to ask that question, and similar to my answer to the last one, I don't think so. I'll just say that more clearly. I don't see how it has that power. Doesn't make sense to me. Okay, one more. Okay, I'll take your question. Yeah, great question. So the question here was if I believe in, and help me if I missed any aspect of your question, I'll try to restate it. If I believe in the original understanding of the Constitution, how much do I think it can adapt and evolve? Can I get that well enough? Yeah, that's a brilliant question as well, a really important one. I'll give you sort of three answers to this question. One answer is, I absolutely believe in the Article 5 of the Constitution. So Article 5 is the provision of the Constitution that provides for amendment. It absolutely can, it has been amended numerous times, it can be amended. Now, it's hard to do. It was made intentionally hard to do because the whole idea of our republic was these are truths that we hold sacred, God-given, and self-evident that we need to protect. And it's only when a super majority of our populace rises up and this broad consensus that it gets amended. But that's my first answer to your question. I think it can be adapted. It doesn't feel very much like the society we live in right now is a society that's going to reach broad super majoritarian consensus about very many things. But we're just looking at right now. We're looking at the post-Trump era. Maybe it's not post. Maybe there'll be another piece of the Trump era. I don't know. But the world we live in today is not the world we'll live in 10 years or 20 years. I still believe in that system. I believe in the amendment process. I hope we will hold on to that. And I think there will come a time when we'll have another constitutional convention. And it can be adapted in that way as well under Article 5. I said I was going to give 3 answers. In the interest of time, I'll just give 2. I think the second answer mostly covers the other one I was going to give. And it's to just go back to what I said about even at the judicial level, judges are supposed to provide for adaptation of the principles of the Constitution to new developments. Free speech as applied to the internet. The Second Amendment as applied to weapons that nobody thought about in the 18th century. The Fourth Amendment, the right to privacy, to be secure against unreasonable searches and seizures, as applied to things like infrared devices. I'll close with this. That kind of judicial decision-making is sometimes hard, and it won't always be obvious how old concepts apply to new applications, but that is a whole lot more predictable and a much better decision-making process than saying, we have no idea what the Constitution means. Our judges should just be politicians in robes. They should just decide what they think is best for us. That is not our constitutional system. I think our constitutional system will fail if and when we continue to tread in that direction. Roe is a decision, there are many others like it, but Roe is a decision from the middle to the late 20th century, where the Supreme Court started acting in some instances like a political body. When you do that, you end up with court packing plans, like the one that I think is not going to succeed, but that's been discussed. Why is there court packing? Well, it's because people are now thinking of the court as a representative body that is just making policy. We can't do that. We have to hang on to originalism. If we don't, our republic will be a joke. Thank you.
For coming. We have a few little gifts for you. First of all, some American Heritage swag. So you can get a picture. And then a few books that we study here. We are big George Washington fans. Here's a quotation from George Washington and his farewell address. And finally, this is a book that we put together last year that talks a lot about American Heritage. Thank you so much. All right, we will end with closing prayer from Deputy Brady, and then if you will all please go to your first period class. Thank you again for being respectful. Wait for the prayer, please. Just sit down and wait for the prayer, and then you can go to your first period class. You're excited to go. We'll just wait for you to sit down and get ready for the prayer. Thank you.
Dear Heavenly Father, thank you that we could all gather here today to learn from Tom Lee, and thank you for the wonderful lessons that we have all had. Thank you for the opportunity to grow with one another and learn from one another. Please bless that we'll be able to have the Spirit with us throughout today and throughout this week, and please bless that the missionaries out in the field will have the Spirit with them also. And I say this in the name of Jesus Christ. Amen.